Dear friends, welcome to EPG Pathshala. Today, we're going to discuss about history of media laws and ethics. The main objective of this module is to understand the history of media laws and ethics. In this module, we will be covering about media laws, ethics, slander, contempt of court, defamation, press council, freedom of speech and expression regulations, and constitutional process. So let's start the module. Till now, you must be familiar with various historical aspects of print media. Now, we would discuss about the essential features of the history of media laws and ethics. You might have come across different articles on media laws, acts or media ethics in newspaper, magazines or tabloids. However, the existence of these media laws, how they came into effect and their historical relevance have a different story. We would know about the journey of media laws and ethics in this module. Once you go through this module, you will be able to assess and distinguish the history of legal framework associated with media and its relevance to society. You will be also able to identify the legal risks associated with the contempt of court, defamation and Copyright Act. You will recognize the constitutional provision of media laws in India. It will help you to understand the regulatory framework of media in association with ethical codes. This will help you to evaluate the relevance of freedom of information law towards society and distinguish between various media acts and their historical relevance. Primarily, this module focused on the history of media laws and ethics, which consist of different laws that regulate the media. We would also learn about Press Act, how it has evolved through various phases. Our country's history is very much rooted in British rule. The media laws and regularities measures can be traced back in 1799. It was the first time when Lord Wesley imposed the press regulation, implemented pre-censorship on newspaper and regulated the printing industry. In 1835, the Press Act Declaration came into existence. There is an extensive list of regularities enacted to delimit the freedom of press. We would further know in detail about various media laws used in regulating the media. Laws related to freedom of the press. Article 19 Clause 1 Subclause A of the Indian Constitution. How it guarantees freedom of the press. First, Press Regulation 1799, Gagging Act 1857, Vernacular Press Act 1878, Indian Press Act 1910, Official Secrets Act 1923, the Press and the Registration of Books Act 1867, Sea Custom Act 1878, Defamation Sections 499 and 500, Contempt of Court 1971, Young Persons Act 1956, Parliamentary Proceeding Act 1956, Delivery of Books and Newspaper Act 1954, Copyright Act 1957, Defence of India Act 1962, Press Council of India Act 1965. The most remarkable day in the history of media regulation was January 26, 1950. It's also the day when the Constitution of India came into force. During colonial practice, Indians understood the importance of freedom of press. However, there is no discrete provision, but an indirect one of the Indian Constitution regarding the freedom of media. The incorporation of such freedom in the Constitution is to vest the press of disseminate knowledge among the masses. The Constituent Assembly decided to maintain this freedom of press as a fundamental right. Even though the Indian Constitution does not explicitly indicate the liberty of the press, but it is manifest in the freedom of speech and expression under Article 19(1)(a). The freedom of speech and expression, however, is not absolute in sense. It is guided by reasonable restriction listed in Article 19(2) in public interest. These reasonable restrictions that apply to individuals are also extensively applicable to the media. Article 19 of our Constitution talks about the right of freedom, and it enumerates defined rights individual freedom of speech, expression, etc. These provisions are significant and vital. We need to keep in mind that this freedom under Article 19(1)(a) is not just applicable to newspaper and periodicals, but also to circulars, leaflets, pamphlets, handbills, and other sort of publication which afford a vehicle of information and opinion. Article 19 of the Indian Constitution lays down, all citizens shall have the right to freedom of speech and expression, to assemble peaceably and without arms, to form associations and unions, to move freely throughout the territory of India, to reside in any part of the territory of India, to acquire, hold and dispose of property, and to practice any profession or to carry any business, trade or commerce. However, the right to freedom and speech and expression shall not affect the operation of any existing law or prevent the state from making any law. The law imposes judicious constraints on the exercise of the right in the interest of sovereignty and integrity of India, the security of the state, friendly relation with foreign state, public morality or decay, or in relation to defamation, contempt of court or incitement to offence. Thus, even though the freedom of the press is guaranteed as a fundamental right, it is essential for us to deal with various laws governing different areas of media, to appreciate the vast expanse of media laws. Richard M. Sismet said, "Our freedom depends in large part on the continuation of a free press, which is the strongest guarantee of a free society. The very basis of democratic government lies on the freedom of press and the freedom of expression. Every business enterprise is involved in several laws of nation, the state, and the community wherein it operates. Newspaper publishers find themselves more hemmed in by lawful limitation than many other commerce do, in spite of the fact that freedom of press is protected by Indian Constitution. The various acts taken into contemplation when dealing with the regulation revived upon the print media. They are the Press and Registration of Books Act 1867. It legalizes printing press and newspaper. In addition, makes registration with appointed authority obligatory for all printing press. Second one, the Press Act 1951. This act is against the printing and publication of agitation to crime and other obscene stuffs. Third one, the Newspaper Act 1956. According to this law, it endorsed the central government to control the price of newspaper in respect to the number of pages and sizes, and to control the allocation of space for advertising matter. First Press Regulations 1799. Lord Wellesley promulgated the first press regulations on May 13, 1799. Conforming to the very regulation, it was obligatory for the newspaper to publish the names and the address of the printer, editors and publisher. However, this regulation was put on an end in 1813 during the regime of Warren Hastings. Gagging Act 1857. On June 18, 1857, a law was sanctioned known as Gagging Act. This act hosted obligatory licensing for owning or running a printing press. It vested the government to forbid the publication or circulation of any newspaper, book or any printed matter. It empowered the government to ban the dissemination or publication of news stories or any such statements which had a propensity to cause hatred or contempt of the government, or weaken its lawful authority, or incite disaffection or unlawful resistance to its order. This act was put on an end in June 1858. Vernacular Press Act in 1878. On March 1, 1878, this act came into existence. The British government imposed this act to exercise more stringent control over the publication in the Indian languages. Under this act, any police commissioner or district magistrate could demand security from the printer and publisher of a newspaper, or forfeit such security, or confiscate any printed matter considered offensive in the interest of the British government. Indian Press Act 1910. Under this act, owners of several press were required to tender security deposits. On printing any objectionable matter, these securities were to be forfeited. Additionally, the police was given extensive power to search and seize. Vigorous prosecution of its provisions accorded the austerity of the legislation. Between 1910 and 1914, the British government initiated about 355 cases. Official Secret Acts 1923. This act deals with offences like espionage and illegal communication of secret information. According to Section 3 of this act, if any person or any purpose violated the public safety and the interest of the state makes it an offence when approaches, look over, passes over, or is in the area of or move in any prohibited place. If a person makes any plan, sketch, model, or note that is calculated to be or might be or is envisioned to be directly or indirectly valuable to an enemy, or obtains, records, collects, or publishes or communicates to any person such sketch, the trial for a wrongdoing under this section 3(1) of this act is about imprisonment for a term which may prolong to 14 years. The Press and Registration of Books Act 1867. This act was passed with a view to assess the present position of newspaper, magazines and books in the country. Act's crucial feature is that each copy of newspaper shall have the names of the publisher, owner and the editor printed clearly. It is mandatory for the printer of every newspaper to deliver 2 free copies of the issue to the state government, which is treated as an offence upon subject to failure. See Customs Act 1878. Section 8C of the Act forbids transporting into India by land or by sea or obscene book, paper, pamphlet, drawing, representation, painting, figure or article. These items can be seized. Defamation. Defamation is tarnishing somebody's image or reputation. Precisely, it is in terms of speaking or writing something detrimental or diminishing the prestige or status of personality of a person or an organization. There are 2 types of defamation: libel, which is a written form; slander, which is a spoken form of defamation. Mr. Dayal in 2010 quotes section 49 of the Indian Penal Code that defines defamation as whoever by words either spoken or envisioned to be read or by sign or by visible representation makes or publishes any imputation in relation to any person anticipating to harm or having reason to be certain of that accusation will harm the repute of such person is said, except in cases hereinafter expected to defame that person. Contempt of Court Act. Under Article 19(2) of the Indian Constitution, contempt of court is one reasonable limitation. In the year 1952, this act came into existence for the first time. Later on, it was enacted in 1971 and then was amended again in 1976. Young Persons Act 1956. This act seeks to prohibit the publication in India of those literatures that glorify crime, violence and vice. Parliamentary Proceedings Act 1956. This act was ordained with a vision to protect the publication of reports or proceedings of Parliament except in newspaper. Section 3 of this act states that no person shall be liable to any proceedings, civil or criminal, in any court, with regard to the publication in a newspaper of considerably true report of any actions of either House of Parliament, lest the publication is proved to have been made with malice. Delivery of Books and Newspapers Act 1954. This act enjoins upon the publisher of every newspaper to provide 1 copy of each issue of such newspaper once it is published, at its own expense to each public library as may be notified by central government. Infringement of any provision of this act becomes punishable. Copyright Act 1957. Section 52 of this act states that certain deeds shall not constitute a contravention of copyright, such as fair quotation, fair use, bona fide abridgments, and the like. Defence Act of India 1962. According to Justice Madholkar, upon the declaration of emergency, the Parliament will be empowered to make laws affecting the freedom of press. It is as if the freedom of media disappears in a situation of emergency. Under a situation of emergency, any law made by the Parliament cannot be challenged on the ground of legislative incompetence for as long as emergency lasts. Citizens are not allowed to claim any security under the provision of Article 19. In addition, in Section 3, the Clause 7 of the Defence of India Act comprehensively deals with the wide-ranging scope of printing and publishing of any sort of newspaper or book of the obligation of censorship. Press Council of India Act 1965. The Press Council of India, according to the preamble of the Press Council of India Act, is established for guarding the freedom of press and upholding and refining the values of both newspaper and news agencies. The experience of the British Press Council has shown that this power, if properly used and constantly exercised, can become extremely effective. The public rebuke that the Council administers and the moral obligation of the offending newspaper to publish its decision operates both as a penalty and a deterrent. The Press Council of India Act 1965 was later amended on March 31, 1970. The Council's term was expired in December 1975. Was not extended during the emergency. Again, the Press Council Act was revised in 1978. The crucial role played by the media laws in the history of Indian independence would also be discussed. The media laws date back on British period when print media was evolving and rising in India. It was acting as an important tool against the British government. Therefore, the government passed and enforced various laws to curb the freedom fighters and their independence movement. Many laws regulate the enhancement of media in India, as media had a powerful influence on society during the British Raj. Therefore, many press-related laws were enacted. However, post-independence, from time to time, more laws related to media came into existence. However, we discussed the Press Act that had a major role in the history of print media. You will further know about the different acts and amendments that happened from time to time to obtain the present-day Press Act of India. The Press Council of India is authorized to build up a code of conduct for news agencies, newspaper and journalists compliant with high professional standards in India. The PCI has conveyed an updated and concise compilation of codes of journalistic ethics sorted out from the Board of Adjudicators of the Council and the guidelines issued from time to time. In 1995, Press Council of India brought out preface to the publication, a guide to journalistic ethics, which states that most of these ethics are not cast iron constitutional rules but comprehensive general principle to help self-regulated journalists to his or her conduct along the way to professional ethics. Norms of journalistic ethics. Patra, in his book titled Media Ethics in 2010, states that some chief norms of journalistic ethics reckoned in the aforementioned publication as under: accuracy and fairness. The vital objective of journalism is to work for the people with views, news, comments and information on the matters of public interest is an accurate, fair, sober, unbiased and decent manner. One should avoid the publication of baseless, inaccurate, misleading, graceless, and distorted material. Cautiousness against derogatory writing. Newspaper must not publish matter which is strongly deprecating or libelous against any person or organization unless after due care and inspection they have adequate reasons to accept as true, and its publication will be for public good. Privacy. Intrusion or invasion of the privacy of individuals is not permissible unless outweighed by genuine public interest. The private life, even of a celebrity, is his or her own. Exposure or incursion of his or her personal privacy or private life is not acceptable, except of course there is strong proof that the wrongdoing is questioned, have a reasonable connection with exploitation of his or public position or power, and has an adverse influence on public interest. Victims of sex crimes cautions against publication of names and pictures. The names, photographs of the victims or other particular leading to their identity should not be published while reporting crime involving rape, kidnapping and sexual assaults on children. While such publication serves no legitimate public purpose, it may bring social ostracism to the victims and social embarrassment to their family, relations, community, friends, religious order or the institution to which they belong. No jeopardizing of supreme interests of state, society and rights of individual. As a matter of self-regulation, newspapers should exercise due restraint and consciousness while representing any comment, news or information which is likely to jeopardize or harm the state and the society interest or individual's right, with respect to which judicious limitations may be waived by law. Importance of ethics in journalism. Mr. Ghosh in 2014 in his book entitled Ethics of Indian News Media, Abbreviation and Future Challenges discussed the importance of ethics in journalism. One of the most discussed and well-defined branches of media ethics is the ethics of journalism. The Society of Professional Journalists Code of Ethics has four main tenets. First, minimize harm. Second, seek truth and report it. Third, act independently. And the last one, be accountable and transparent. It has to deal with a variety of things, together with manipulation of content, distinction between public interest and privacy of individuals, or confidentiality and conflict with the law of the land regarding protection of news sources need to be looked into. Thus, it is imperative for the budding journalist to know the history of media laws and ethics in order to get acquainted with various media laws and ethics. It is vital to have a deep knowledge of the roots and the reasons of the enacted of these laws and code of conduct for the media. In order to be an unbiased journalist, one has to abide to these laws and ethics. Journalists have to act freely not only for the sake of upholding ethical standards, but also for safeguarding their freedom and their constitutional rights. Journalists play a dynamic role in the public to understand and forming an opinion. Therefore, they must remain thoughtful towards different issues which are sensitive, such as fairness, accountability, and accuracy. They must always question themselves regarding ethical practice throughout various stages of their investigations. In addition to that, they must be ready to justify their decision to colleagues, editors, and the public in this respect. Usually, it is tougher to perform tasks in an ethical way and accomplish it, but all journalists should be ready to face such challenges if they want to safeguard the sanctity of media. So friends, we have covered the media laws and ethics in this module. We have covered up how the pre-independence era was affected by media laws and how it has changed from that time to the post-independence era. So we have discussed about the media laws and the ethics by journalists that should be followed by them to make the society bias free. Thank you.